Negotiation is a crucial skill in both personal and professional life. Whether you're negotiating a salary increase or a business deal, the ability to communicate effectively and reach a mutually beneficial agreement can make all the difference. In addition to negotiation, contract drafting is another essential skill for anyone involved in business or legal transactions. A well-drafted contract can ensure that all parties involved understand their obligations and responsibilities, leading to a smoother and more successful partnership. In this course on negotiation and contract drafting skills, we will explore the principles and techniques of effective negotiation, including preparation, communication, and compromise. We will also delve into the key components of contract drafting, from legal terminology to dispute resolution provisions. By the end of this course, you will have the tools and knowledge to negotiate effectively and draft clear and concise contracts that protect your interests and lead to successful partnerships. Number 1. Negotiation is a process of communication and compromise between two or more parties with differing interests, aims, or viewpoints. Negotiation is an essential part of our daily lives, whether we realize it or not. It happens when you're deciding where to eat with your friends, discussing a raise with your boss, or making a major purchase. It's a process of communication and compromise, where two or more parties come together to find a solution that works for everyone involved. At its core, negotiation is about finding common ground. When parties have differing interests, aims, or viewpoints, it can be challenging to come to an agreement. But with effective communication and a willingness to compromise, even the most challenging negotiations can be successful. The key to successful negotiation is preparation. Before going into a negotiation, it's important to know your goals and priorities, as well as those of the other party. By understanding the other party's interests and concerns, you can find ways to create a mutually beneficial agreement. Active listening is also crucial in negotiation. It's important to truly hear and understand the other party's perspective, as well as to communicate your own interests and expectations clearly. Negotiation isn't about one party winning and the other losing. Instead, it's about finding a solution that works for everyone involved. This may mean compromise on both sides, but it ultimately leads to a stronger, more positive relationship between the parties. In conclusion, negotiation is a vital skill for anyone who wants to succeed in business or in life. By approaching negotiations with an open mind, clear communication, and a willingness to compromise, parties can find common ground and create agreements that work for everyone involved. Number 2, effective negotiation requires preparation, active listening, and clear communication of interests and expectations. Have you ever felt like you didn't get what you wanted out of a negotiation? Maybe you didn't prepare well enough, or perhaps you weren't listening carefully enough to the other party's needs. Effective negotiation requires more than just showing up and hoping for the best. It requires preparation, active listening, and clear communication of interests and expectations. Preparation is key in any negotiation. You need to know your goals, understand your limits, and have a clear idea of what you're willing to compromise on. Without proper preparation, you may find yourself in a weak position, making concessions that you wouldn't otherwise make. Active listening is also a critical component of successful negotiation. You need to be able to hear and understand the other party's perspective, even if you don't agree with it. This allows you to identify areas of common ground and find ways to create a mutually beneficial agreement. Clear communication of interests and expectations is essential in negotiation. You need to be able to articulate your needs and priorities clearly, and you also need to be able to understand the other parties. By doing so, you can work together to create a solution that meets everyone's needs. In conclusion, effective negotiation requires preparation, active listening, and clear communication of interests and expectations. By approaching negotiations with these skills in mind, you can increase your chances of success and create agreements that work for everyone involved. Remember, negotiation isn't about winning or losing, it's about finding a solution that works for both parties. Number 3, a successful negotiation results in a mutually beneficial agreement that satisfies the interests of all parties involved. Negotiation can be a daunting process, especially when parties have differing interests and goals. However, a successful negotiation can result in a mutually beneficial agreement that satisfies the interests of all parties involved. In other words, everyone wins. A successful negotiation isn't about one party coming out on top while the other party loses. Instead, it's about finding a solution that meets the needs and priorities of all parties involved. This may require compromise and creative thinking, but it ultimately leads to a stronger, more positive relationship between the parties. One key to achieving a mutually beneficial agreement is to focus on common ground. Even when parties have differing interests or goals, there are often areas where their needs overlap. By identifying these areas and working together to find a solution that satisfies them, parties can create a win-win situation. Another important factor in achieving a successful negotiation is open communication. Parties need to be able to express their needs and priorities clearly, as well as listen actively to the other party's perspective. By doing so, they can find ways to create a solution that works for everyone involved. In conclusion, negotiation doesn't have to be a zero-sum game. With a focus on common ground, open communication, and a willingness to compromise, parties can create agreements that satisfy everyone's interests and needs. By doing so, they can build stronger, more positive relationships and set the stage for future success. Number 4, contract drafting is the process of writing and creating a legally binding document that outlines the terms and conditions of an agreement. Contracts are a vital part of business and everyday life. They provide a clear and legally binding agreement between two or more parties. But before a contract can be signed, it must be drafted. Contract drafting is the process of writing and creating a legally binding document that outlines the terms and conditions of an agreement. A well-drafted contract should be clear, concise, and easy to understand. It should outline the responsibilities and obligations of each party, as well as the consequences of any breaches. The contract should also include provisions for dispute resolution and termination. The process of contract drafting requires a thorough understanding of the law and the specific terms and conditions of the agreement. It's important to consult with legal professionals to ensure that the contract is enforceable and compliant with relevant regulations and laws. Another important aspect of contract drafting is attention to detail. Small errors or omissions can have significant consequences down the line. For example, a missing comma or unclear language could result in a dispute or even litigation. In conclusion, contract drafting is an essential part of creating a legally binding agreement. It requires a deep understanding of the law, attention to detail, and clear and concise language. By ensuring that contracts are well drafted, parties can avoid disputes and build stronger, more positive relationships. Number 5, effective contract drafting requires a clear understanding of the goals and expectations of all parties involved, as well as knowledge of legal principles and terminology. Contracts are legal documents that play a critical role in business and everyday life. Effective contract drafting is essential for creating a document that accurately reflects the goals and expectations of all parties involved. This requires a clear understanding of those goals and expectations, as well as knowledge of legal principles and terminology. Before drafting a contract, it's important to take the time to understand the needs and priorities of each party involved. This allows for a contract that is tailored to meet those needs, while still complying with legal requirements. It's also essential to be clear about what is expected from each party, including obligations, deadlines, and consequences for breaches. Effective contract drafting also requires a deep understanding of legal principles and terminology. This includes a knowledge of relevant laws and regulations, as well as an understanding of legal concepts like indemnification, warranties, and force majeure. Failure to understand these principles can result in a poorly drafted contract that fails to protect the interests of all parties involved. In addition to legal knowledge, effective contract drafting also requires strong writing and communication skills. The contract should be written in clear, concise language that is easy to understand. It should also be free from ambiguity or potential for misinterpretation. In conclusion, effective contract drafting requires a clear understanding of the goals and expectations of all parties involved, as well as knowledge of legal principles and terminology. By taking the time to understand these factors and drafting a well-written and clear contract, parties can create agreements that are legally enforceable and meet the needs of everyone involved. Number 6. Contracts should be drafted in clear and concise language, avoiding ambiguity or vague terms that may lead to confusion or disputes later on. Contracts are a critical part of business and everyday life, and they play a significant role in defining the relationship between parties involved. However, if a contract is not well written or contains vague or ambiguous language, it can lead to confusion or disputes down the line. That's why it's essential to draft contracts in clear and concise language. A well-drafted contract should be written in language that is easy to understand, even for individuals who are not legal experts. It should be free from jargon, technical terms, or complex language that could lead to confusion. Instead, the language should be simple and straightforward, using terms that are commonly understood. Ambiguity and vagueness should also be avoided when drafting a contract. This means that the language used should be specific and leave no room for misinterpretation. For example, if a contract specifies that a party will be paid a fair amount, it leaves open the possibility of interpretation and could lead to disputes. Instead, specifying an exact amount or method of calculation removes any potential ambiguity. Clear and concise contract language is especially important when it comes to defining terms and conditions. If these terms are unclear or ambiguous, it can lead to disagreements down the line. By specifying the responsibilities and obligations of each party in clear and concise language, parties can avoid disputes and build stronger, more positive relationships. In conclusion, contracts should be drafted in clear and concise language that avoids ambiguity or vague terms that may lead to confusion or disputes later on. By taking the time to draft contracts in a way that is easy to understand and leaves no room for misinterpretation, parties can create agreements that are legally enforceable and meet the needs of everyone involved. Number 7. Specific terms such as payment schedules, delivery dates, and performance expectations should be clearly outlined in the contract. When it comes to drafting a contract, it's essential to be as specific as possible. One of the key areas where specificity is important is in outlining the terms and conditions of the agreement. This includes details such as payment schedules, delivery dates, and performance expectations. By clearly outlining these specific terms in the contract, parties can avoid misunderstandings or disputes down the line. For example, specifying payment schedules and deadlines ensures that both parties understand when payment is due and what the consequences are if payment is not made on time. This can help prevent delays or disagreements. Similarly, outlining delivery dates and expectations ensures that both parties understand what is expected and can plan accordingly. This can help prevent delays or other issues that could impact the project or relationship. Performance expectations should also be clearly outlined in the contract. This includes details such as quality standards, timelines, and expected outcomes. By specifying these expectations, parties can ensure that everyone is on the same page and working towards the same goals. In addition to preventing misunderstandings or disputes, outlining specific terms in the contract can also help build trust between parties. By showing a clear understanding of each other's needs and priorities, parties can demonstrate a commitment to working together towards a common goal. In conclusion, when drafting a contract, it's important to be as specific as possible. Specific terms such as payment schedules, delivery dates, and performance expectations should be clearly outlined in the contract to prevent misunderstandings or disputes down the line. By taking the time to clearly specify these terms, parties can build trust and work together towards a successful outcome. Number 8. contracts should also include provisions for dispute resolution, such as mediation or arbitration, in the event that conflicts arise. No matter how well drafted a contract is, conflicts can still arise between parties involved. In such cases, it's crucial to have a provision for dispute resolution in the contract. This provision outlines the steps that parties can take to resolve any disputes that may arise, preventing disagreements from escalating into legal battles. Two common methods of dispute resolution are mediation and arbitration. Mediation involves a neutral third party who assists the parties in reaching a resolution that satisfies everyone involved. In contrast, arbitration involves a neutral third party who makes a binding decision on the dispute, similar to a court ruling. Including provisions for dispute resolution in a contract can help prevent costly and time-consuming legal battles. It provides a clear framework for resolving disputes and ensures that all parties understand what steps they can take if a disagreement arises. Furthermore, including provisions for dispute resolution can also demonstrate a commitment to working collaboratively towards a successful outcome. It shows that parties are willing to engage in constructive dialogue and work towards a solution that benefits everyone involved. In addition to specifying the method of dispute resolution, contracts should also outline the procedures and timelines involved. This can include details such as how the dispute will be initiated, the role of the neutral third party, and the timeline for resolution. In conclusion, contracts should include provisions for dispute resolution, such as mediation or arbitration, to prevent disagreements from escalating into costly and time-consuming legal battles. By specifying the method, procedures, and timelines involved, parties can work collaboratively towards a successful resolution that benefits everyone involved. Number 9. Before finalizing a contract, all parties should carefully review and negotiate the terms, making sure that everyone agrees to and understands the contents. Finalizing a contract is a critical step in any negotiation process, and it's essential that all parties involved carefully review and negotiate the terms before signing on the dotted line. This is because once the contract is signed, it becomes a legally binding agreement, and any disputes or issues that arise later will be governed by the terms outlined in the contract. Before finalizing a contract, it's crucial to review all of the terms, including any clauses or provisions that may be unclear or ambiguous. This can involve seeking legal advice to ensure that the terms are fair, reasonable, and enforceable. If any issues or concerns arise during the review process, it's important to discuss these with the other parties involved and negotiate the terms until everyone agrees. This may involve making compromises or adjustments to the terms to ensure that all parties are satisfied. Once all parties have agreed to the terms, it's essential to document these in writing, and have all parties sign the contract. This creates a record of the agreement and ensures that everyone is aware of their obligations and responsibilities. Carefully reviewing and negotiating the terms of a contract before finalizing it is crucial to prevent any future disputes or misunderstandings. It ensures that everyone is on the same page and understands the contents of the agreement, which ultimately leads to a successful and mutually beneficial outcome for all parties involved. In conclusion, finalizing a contract is a critical step in any negotiation process, and all parties involved should carefully review and negotiate the terms before signing. This helps to prevent any future disputes or misunderstandings, ensures that everyone is on the same page, and ultimately leads to a successful and mutually beneficial outcome for all parties involved. Number 10. Ongoing communication and cooperation between parties is key to maintaining a successful business relationship, even after the contract is signed. A successful business relationship goes beyond the signing of a contract. Ongoing communication and cooperation between parties are critical to maintaining a positive and fruitful business relationship. Even after the contract is signed, it's important to continue to communicate and work together to ensure that both parties are satisfied and benefiting from the agreement. Regular communication is vital to address any issues or concerns that may arise, and to ensure that everyone is aware of their obligations and responsibilities. This can involve setting up regular meetings or check-ins to discuss progress and provide updates on the project or service outlined in the contract. In addition to communication, cooperation is also important to maintain a successful business relationship. This can involve working together to find solutions to any problems that arise, making compromises when necessary, and being flexible and adaptable to changes or unforeseen circumstances. By maintaining ongoing communication and cooperation, both parties can work together to ensure that the contract is being fulfilled and that the business relationship remains positive and productive. This can lead to long-term partnerships, repeat business, and a strong reputation in the industry. In conclusion, ongoing communication and cooperation between parties are key to maintaining a successful business relationship, even after the contract is signed. Regular communication and cooperation can help to address any issues or concerns that arise and ensure that both parties are satisfied and benefiting from the agreement. By working together, both parties can build a positive and productive business relationship that can lead to long-term success and growth.